All right, welcome. We're starting a series of new chapters. These chapters are a new unit, Unit 6, in your text, although obviously um, it's the second unit we're looking at in business law too, so try not to be confused about that. Um, we're going to be looking this first new chapter at creditors' rights and remedies, and this has got a few catch-all things in it about liens, and one of the things I've done in this one is to include um, a few more specific things for North Carolina than in your text. Although, again, don't worry too much because your textbook is controlling information in regards to testing. I'm just putting a lot of this extra North Carolina stuff in unless I expressly tell you for it to be on a review or something, just for your edification and so that you understand how things work in North Carolina. Okay, so let's go ahead and jump in. The first thing we're going to talk about are some laws that assist creditors. We're going to talk about a lien. In fact, we're going to mention 4 types of liens. We're going to talk about mechanics liens. We're going to talk about artisans liens. I'm going to refer very, very briefly to innkeeper liens, even though they're pretty rare. And then we're going to talk about judicial liens. So basically, a lien is a process whereby you file a claim. As opposed to usually against an individual, it's against a piece of property. And we usually will say it's either a possessory lien, which means you've got to possess that piece of property, or not. It might mean against a third party. So it's putting the world on notice that you're owed money and that you will get the money from this thing. So as I said, there's 4 that we're really concerned about, the last one being by far the most important. Mechanics liens, artisans liens, innkeepers liens, judicial liens. Let's talk about each one of those in turn. Okay, so a mechanics lien, we're using some kind of old language here. You have to remember that when the term mechanic first comes into the English language, no, not completely, but for simplification's sake, it's probably closer to something like carpenter or worker like that. So when we're talking about a mechanic in the old sense of the word, which is carried over into the law, a mechanics lien, is when you do something for real property, for real estate. So if you went in and installed a sink like a plumber, or if you put in kitchen cabinets like a carpenter, or put a floor down, or put in lighting in a house, and you didn't get paid, what you could do, and I'll show you a form of those in a bit, is that you can file a lien against that property. Now, very often, this really comes more into play when people sell their houses. Because let's suppose you didn't pay off someone that did work in your house, and it's a relatively small amount of money, such that we wouldn't go through a foreclosure for it, or it would be unlikely we go for a foreclosure. When you go to sell that house, in order to convey clean title, you're going to have to pay off that lien. Otherwise, very often banks and things won't let you go through the closing. Now, an artisan's lien is a little different. An artisan's lien is a possessory lien. And by that I mean that if you're going to claim you want to get paid from this thing, as opposed to a house that's sitting on a piece of land, up on Main Street, an artisan lien means you've actually still got the thing. So an example here would be, let's suppose I take my vacuum cleaner in for repair. And when he fixes it, he says, that'll be $100. And I say, well, that's just too much money. I'm not going to pay that. Give me my vacuum cleaner. Well, the guy can say, well, no, you owe me the money. Okay, and I'm going to slap an artisan's lien on this, and if you don't pay me that, I'm going to sell what I possess, which is your piece of property, pay off my debt, pay off what you owe me, okay, and then if there's anything left over, you can recover some. But if I gave the vacuum cleaner back and then I said, okay, you owe me $100, it's like, well, I'm not going to pay you. The only thing I can do there is I can't file an artisan's lien. I could just sue you. Now the last one, which is pretty rare, although you have to be careful in the law when you say things are rare because sometimes they come back around, is an innkeeper's lien. And if you kind of think of the old black and white movies, in the old days you see these bellhops. Well, the bellhops existed for a reason. They would go up and get your bags, and then they'd bring them downstairs or bring them to the front desk, and they'd put them by the front desk and they'd give you your bill. Now that was very intentional because if you didn't pay your bill, they kept your bags. So they didn't really want you taking your bags up and down to your room. They wanted to control it. Again, it's a possessory lien. You don't see it very often anymore because most of the time when you're checking in a hotel, motel, you're going to give them a credit card. The next thing I'm going to show you there is a claim on real property. This would be a mechanics lien form in North Carolina, and this would be something you would file downtown. You'd file these with the Register of Deeds, and there's the North Carolina General Statute, Chapter 44A, Section 12. But just so you can see one. Now, I said by far the most important is really the next kind of lien, which is your judicial lien. So in a judicial lien, you can get these they're pretty rare. You can get these before you go to court, but most of the time they exist after you have a lawsuit and somebody loses and somebody owes money. So the most common one, like I said, there are very rarely prejudgment remedies, but the most common one will work like this. Abel sues Baker, and Abel wins. So Abel wins $1,000. So Baker owes Abel $1,000. And Baker says, well, I'm not going to pay. Now, it's a civil matter. You can't arrest him for not paying. But you have to have some sort of mechanism to collect the money, and this is the judicial lien. So Abel will file a judicial lien. And the first thing they'll do, so Abel's owed $1,000, is we'll get a writ of execution. Now, that sounds a lot worse than it is. But a writ of execution is an order, that's all a writ is an order, to some agency of the state, in this case the sheriff, typically in North Carolina, to go out and take Baker's property to sell it at auction and pay off that debt. Now, one of the things that happens in these judicial liens very, very, very often is that you've got property that is exempted from collection. So let's suppose someone's crippled and in a wheelchair. You don't want a writ of execution that says, okay, you can take the wheelchair. So there is exempted property. So when I sued somebody, if I filed a lawsuit and I won, one of the first things I would do, because sometimes you would deal with people that were somewhat irrational and you would win and they would say, well, I'm never going to pay you. I hate your stinking guts. All you lawyers are destroying the world. One of the things I would do is I would send them what's called in North Carolina a notice of rights exempted. And quite simply, that's just telling them that certain property can be exempted from this collection. And sometimes they would fill these things out and send them in and say, well, I want to protect this piece of property and this piece of property because this helps me earn a living, or this is part of medical, or this is something exempt, or this is what I owe with my, all sorts of reasons. But very often they'd rip it up and throw it away because it came from me. But 30 days after I win, I would go over to the sheriff's department with a writ of execution. And here is this next slide, a writ of execution in North Carolina. It's a little out of focus. I apologize for that. But basically, it's a form. You can see that. It says writ of execution. It's got the two parties. This would be Abel suing Baker. And it talks about first, what is the principal? So it was $1,000. Now, what about this other stuff? What is the court cost? What is interest that's due on it? Plus other, which could be collection. So it would give you a total due today. And it might be $1,200, $1,500, or if it was a very old debt, it might be $5,000. Now, you are commanded to pay this, and if you can't, when I walk over to the sheriffs, they stamp it. They send a couple sheriffs out. They send them out with a van. They say, "All right, Mr. Smith, you owe $1,000 to, excuse me, Mr. Baker. You owe $1,000 to Mr. Abel." And Abel says, "Yeah, I got sued, but I'm not going to pay it. I hate your stinking guy." Fine. We're here to take stuff. And they will go into your house or your garage, and they'll load up with tools and TVs and things that are of value, even furniture. Then they will take it downtown, and it will become part of a sheriff's sale. So when you go to, every county has a sheriff in North Carolina. There's 100 counties, 100 sheriffs. And every sheriff will conduct these sales every now and then. And that money, most of the time what's being sold there is part of a writ of execution. They'll then take that money. Let's suppose that they take your couch and a TV and you know, some tools and stuff from the garage. And let's suppose they sell it all and they get $500. Okay, so they'll apply that as to what the total is due today. Now, there can be extra money, you know, like I said, it might have been $1,000 debt, but to collect it, to pay for the sheriff, pay for the sale, they might be charging money. So it might be a $1,200 debt. So they'll take that $1,200, they sold $500 worth, you still owe $700. 1,200 minus 500 is 700. The nice thing about this is I can go out and do this again. You go out and you buy a new TV, great, I'll wait 30 days, I'll send a sheriff out again. Or we can agree on paying this thing off. Now the next type of remedy is a garnishment. And these used to be a lot rarer than they are now. When I first started practicing law, the most common thing I saw it for, the most common thing by far, was child support followed by taxes. What this essentially does is you never see the money. I go to your boss and I say, Mr. Baker owes me $1,000. And I know that he gets $500 a week. Therefore, I want a percentage of that money every week deducted until I'm paid off. And if it's a lawful garnishment, the employer has to obey. Now, there can be limits on, first of all, what income can be subject to garnishment. Pensions are exempt. Social Security is exempt. And also, it can't go beyond certain amounts. Like they couldn't take 100% of your wages. Now, I said this used to be rarer, but nowadays it is becoming a little bit more common again. Some creditors are getting some of these old debts. They're getting an issue. They're getting basically an order to garnish wages. Whereas that used to be a little bit rarer, now it's become common again. I'd be interested to see if this continues. Creditors' composition agreements. This is a contract with the debtor to discharge a liquidated debt. So let's suppose I owe you $10,000. And I say, look, I don't have $10,000. If I go into bankruptcy, you'll get pennies on the dollar. But I'm willing to pay off $5,000, 50%. You could have an agreement between a debtor and a creditor called a creditor's composition agreement, whereby you would agree to settle for that $1,000 for $500. Now, there is, again, it's beyond the scope of this course. There is some tax liability here because if you get forgiven a debt, that is taxable income. So you should be aware of that. All right, the big one to talk about in this unit is mortgages. And most people who own houses, and house ownership is pretty common in the United States, have some type of mortgage, at least initially, although interestingly enough, I think I saw a statistic that 1/4 of homes have no mortgage on them, usually older homeowners who paid them off. So what's a mortgage? Basically, it gives a creditor, usually the bank, a lien on real property. Now, they go by different names in different locations. Usually there is a promissory note, which is a piece of paper that says how much money you're owed. And that promissory note, and I'm going to show you an example of that in a little bit, is secured by a deed of trust. And together, that's usually what's called the mortgage. So usually you have a down payment. So if let's suppose my house is $100,000. Usually in order to avoid things like PMI, which is private mortgage insurance, you got to come up with, say, 20%. So you have to put $20,000 down. If you don't, it's usually either a more expensive interest rate or you have to pay an insurance. Now, mortgages come in a ton of different shapes and sizes. There is the fixed rate mortgage. And what we do in a fixed rate mortgage is we say, okay, you're going to pay 5% on money. Now, right now, mortgage rates are very low. Historically, although and they have gone very high at times. I mean, in the 70s or beginning of the early 80s, they were quite high. Sometimes, the prime rate got over 20%, and you can imagine what a mortgage would be. But usually, they don't want you paying more than about 25 or 30% of your gross monthly income. There are, as I said, all sorts of specialty ones. Now, usually you've got a fixed rate is a slightly higher rate, and an adjustable rate, at least to start with, is a lower rate that can go up later. But as I said, there is a ton of different types here, including things like balloon mortgages and interest only. But here's an example of a North Carolina promissory note, which you would sign when you bought a house. Okay, so okay, I'm borrowing this much money. Here are my payments, and over here is a deed of trust. Now that would be filed um, downtown at the Register of Deeds, and that would let everybody know that this money was owed on the house. So it puts people on notice, and when I'm an attorney and I'm doing a closing, it lets me know that money is owed. So you have to pay off this first mortgage, or second mortgage, or third mortgage, whatever it is. All right, there is some protection here. As I said, usually if you can't put down a significant amount of equity, if you don't have skin in the game, the person lending you the money, usually a bank, is going to require mortgage insurance, which is a premium you pay every month that if you don't make your payment, they're going to get some money. That's what a PMI is. It's a profitable insurance. Banks like it. The other thing that protects is it's recorded. It lets we take that deed of trust, that last thing we saw, and we record that downtown so that everybody knows that this piece of property on Greenacre is subject to a mortgage and a deed of trust and a promissory note. There's also typically contract provisions. One of the things that's common now, not as much in North Carolina because we like prepayment, is there can be penalties for prepaying, for paying too early mortgages. That's something you need to be aware of. Also, almost every mortgage deed of trust packet, because it comes as a big packet to the lawyer that's going to do the closing, is going to require you to have and maintain homeowners insurance. And if you don't, they will go out and buy it, and then they will charge you for it, and it won't be cheap. They won't find you the best deal. Often they'll deal with themselves. All right, well, sometimes, sadly, people can't pay. So we have foreclosure, and this is the process of collecting on a debt owed against a house or piece of property. And what you're looking for is, if I'm owed $80,000 and the house is worth $100,000, I'm going to sell that house, hopefully for $100,000, and I'm going to get $80,000 and give the other $20,000 back to the homeowner. We're assuming that nobody here is underwater. Now, creditors in a foreclosure, if they can pay off the debt, the interest and collection costs, have a right of redemption. They can stop the foreclosure. It's not, once it's going, it's there. There are alternatives to foreclosure because sometimes banks don't want to go there. Right now, because of COVID, you've got a tremendous number of people that are basically on hiatus from paying their mortgages. Their debt is being held outstanding and there's no foreclosure. So you can also have instances like forbearance where I don't want to collect, so let's forgive some or all the outstanding debt and we'll agree to a new debt. Workout where we agree to new payment rates. Short sale, let's sell the property for less and let's call it even. Or and this was a little bit more common in the 1800s, assignment for the benefit of creditors, where you transfer title of the good to a trustee, so the property goes to a trustee, and that person holds it for the benefit of the debtors. And usually debtors can accept or refuse the percentage payment under this scheme, and sometimes they prefer it because of issues of accounting issues really that have a lot to do with having to declare loans performing or non-performing. All right, now we're going to enter into two other kind of unique things. We're going to talk about sureties and guarantees. So what's a surety? A surety is when you promise to be liable for the debts of another, no matter what. So what would a surety be like? Well, let's suppose my son goes to buy a car, and they say, well, you know, your son's not as good a risk as you are, Mr. Chapman, so you sign as a suretor. I say, well, you know, I trust my son Ben, I'll sign, so I sign. And let's suppose Ben doesn't make the car payments. At that point, the dealership, ABC Motors, doesn't have to go after Ben. If there's a suretyship, they can go after me. They can say, all right, you signed, give us the money. And I can say, well, you should get it from Ben. They say, oh, we'd rather get it from you. You got money. He's young. Now, most of the time, 99% of the time, these are going to be in writing to be enforceable. Debtors much prefer surety as opposed to guarantee, which I'm going to talk about next. What's a guarantee then? Well, a guarantee, same basic scenario with one big kind of twist. I go in and I say, all right, I'll answer for the debts of another, but only if they don't pay. So I signed for my son, Ben. Okay, Ben doesn't pay. They can show he defaults. They can go after Ben first. He can't pay. Now they go after me. You can't go after me first. You got to go after Ben first. You have to proceed against the original debtor. Try to collect from them. Now, guarantees have to be in writing. Now, realistically, so are suretyships, but they have to be in writing. One of the things about guarantees is they can be limited or unlimited. So it can be, all right, I'll guarantee payment for the first year. They might say, okay, well, that's good enough. He pays the first year, we're happy. It could be an absolute guarantee, immediately liable if there's a default, or it can be conditional, not if such and such and such happens. So again, since this is kind of more a contract, you can shape it in almost any way you want. All right, there are defenses of sureties and guarantees. Let's suppose I sign as a surety or guarantee, and Ben, he buys a practical car, a Prius. Okay. And then he says, you know, I really want a Corvette. So he goes back to the dealership and says, let's trade this in on the Corvette. And they say, well, yeah, you got a guarantee ship, surety ship from your dad, so yeah, we'll do that. And he gets a Corvette, which is impractical. What happened there is that materially modified the underlying payment, the underlying collateral. Unless I was to sign off on that, they're releasing me from the liability of signing. Also, you have to be aware that any defenses available to the principal debtor are generally available to the surety or guarantor, unless you're going to say, well, they're bankrupt. That's not a defense for me to pay. Infant, that means my son would be under 18 typically. Or there's a statute of limitations. If the creditors turn over collateral to the debtor, that's surrender, that would be a defense. Some defenses, like infancy, bankruptcy, incapacity, may be a defense for me. If I go bankrupt, that's a defense to payment, but not, it's a defense if they go, if my son was to go bankrupt. All right, some of the rights you get as a suretor or guarantor. Right of subrogation. When the surety pays, he can sue the debtor to correct. And it's very closely related to reimbursement, the right to sue for the costs of the surety or guarantee. So, you know, if I'm doing this for someone and they said, well, if you'll sign as guarantor, I'll pay you such and such, or I'll give you extra money to me, then if they didn't, I could sue. And there's right of contribution. If two parties sign, so let's suppose you have a husband and wife who are divorced, and they each sign as a surety or guarantee for their son's new car, and he doesn't pay. And they come after the husband, or they come after the wife, we'll say, because she's got the money, and she winds up paying $10,000. She can go to the ex-husband and say, okay, cough up your 5. Cough up your percentage that you owe. Protection of debtors. There are exemptions. If you remember when we were talking last time about notice of rights exempted, when we were talking about judicial liens and such, there are certain property that is not subject to being taken to pay debt. So, you know, a classic example here would be health stuff. So you're on oxygen, and you've got a setup to give you oxygen that keeps you alive. You owe money, they come to foreclose. Can they seize the oxygen? No. Also, every state can set certain values that can't be seized. Homestead, this is the equity in your home. North Carolina protects up to $25,000 of your home's equity value. Household goods to a certain amount can be protected. Again, there's going to be real numbers here. Clothing and some personal protections can be protected. Vehicles used for transportation up to a certain amount. Again, varies from state to state, so I'm not going to give you hard numbers here. Animals, livestock being here mainly because they're producing, but also pets. You can't foreclose pets. Um, Equipment. These are things used in tools of trade. All those can be protected. Okay. There's also some special protections. I'm just going to mention these because I want to keep this relatively short chapter in about a half an hour, and I could spend a long time talking about special protection for consumer debtors. Starting really in the 1960s and continuing through the 70s in particular and into the 80s, and then dying out a little bit, there was a number of protections made for consumer debtors. So one of the things that exists is if you contacted or contracted a debt for a consumer credit transaction, there can be special federal and state protections for this. Now, most of the time, let's just take automobiles as our example here. If you go to buy a car, they're going to have to give you, if they're loaning you the money, for example, the actual APR, annual percentage rate. They can't say, oh, you're only paying 5% in one, and then it turns out, well, no, if you factor in your down deposit and everything else, it's actually 10%. They got to give you real factual information. How many payments you got, total amount of money you're borrowing, all the information that would be important if you were making a wise financial decision about what is the debt, how much money are you actually borrowing. And this, I've been in real estate closings where a person is borrowing, say, $200,000 to buy a house in a 30-year mortgage. And they come and they say, okay, depending upon the interest rate here, the amount of money you're borrowing is not $200,000 because there is discounts or points. You're only borrowing $190,000, right? You're going to pay over the life of the loan that $190,000 back, plus you're going to pay another $200,000 of interest over the. And people are like, sometimes they're shocked. Like, oh my God, that's what I pay in 30 years? Yeah. There's a lot of interest that builds into this. So you try to make people aware. And again, there can be specialized protections. If you're doing a home closing, housing and urban development, there's what's called a HUD form. And if you look at those HUD forms, they lay out for you in very specific detail what you're borrowing, what your payment is, how the payment's broken down. And this is something that everybody has to sign and is really important. Now, we're going to talk about residential real estate, but basically, you have to remember one thing, and I'll leave you with this thought. When you're in a real estate closing with an attorney, the one that you're paying, he in theory is the only person in that room representing your interests. So what I would do I would call people in and say, okay, I'm going to do this closing. If you don't want to do this closing, if there's a problem, you tell me and I'll be the bad guy. You tell me and I'll disappoint the realtor and I'll disappoint the bank and I'll disappoint the seller. There can be costs for this, but if there's an issue, let me know because you're paying me money to represent you. And that's what you want. Look, lawyers get paid to be yelled at. And it's something we all accept. I'm just going to accept the fact that people are going to tell lawyer jokes and people are going to be insulting. So when you've got a debt, I want you to know everything about that debt. I want you to know the facts. I want you to know the interest. I want you to know the principal. I want you to know, okay, here's what it is. And if you're not happy, I shouldn't be happy. And we should be able to stop this trend. And I've stopped real estate closings like this when there's been issues for debts and other things. Now, of course, this doesn't just happen for real estate. I don't want to leave you with the idea that only during real estate you have protection. You have protection with a lot of consumer credit things. You have protection in purchase of automobiles. You have certain consumer protection. And of course, we just created, I say just, 4 years ago or so, more than that now, we just created a consumer protection agency. First head of that was, what's the senator from Massachusetts? Elizabeth Warren. She was the first head of it. And by the way, businesses friggin' hate the Consumer Credit Agency because they want to maximize their advantage. I completely understand that. Whereas if it hasn't been captured, The Consumer Credit Agency should be maximizing the protection for the consumers. So just be aware that there can be special protection for you depending upon where we are. All right, well, that brings us in right at about a half an hour. We'll leave it there. Fare thee well.